Well, good afternoon, ladies and gentlemen. I'll call this special meeting of the Missoula City Council of June 1st, 2017 to order. Please let the record note that all council members are present with the exception of Mr. Hess, Ms. Armstrong, and Mr. Wilkins. We have an opportunity for public comment on non-agenda items. Any general public comment? Seeing none, we'll move on to our only order of business today. This is the Water System Settlement Agreement and Bond Resolution Amendment, and I have an introduction. The City of Missoula has long held an interest in bringing its water system into public ownership, though the first and I believe last legitimate opportunity to do so in recent history arrived with the purchase of Park Water Company by Carlisle Infrastructure Partners in 2010. Before that, the company was owned by an unwilling seller to the city who happened to be a decent sole proprietor with interest in the communities his companies served and the employees who served those communities. The list of reasons for public ownership of water systems is imperative and has only grown over the course of the last 7 years. But the fundamental reason remains: a privately held monopoly operating a water system for profit and the benefit of distant investors will never serve the long-term interests of the public it should serve. What we've seen under global corporate management is increased rates, higher profits leaving the community, and decreased investment in the critical infrastructure that supports Missoula, Montana. Now, as we look across the country, we see rates increasing under private ownership without proportional investment in those water systems. We see the commoditization of water, an essential resource, and a pattern of flipping utilities, which are barely regulated by overburdened and understaffed public utility commissions for incredible profit. Remember, Carlisle purchased Park Water for about $150 million in 2010 and sold it in the dark of night to Liberty Utilities for about $317 million in 2015. The reason? Water utilities are cash cows, monopolies that line investor pockets to the detriment of the communities they should be obligated to serve. There may or may not be villains in this tale, but there are victims. We presented evidence in our successful condemnation lawsuit that the Mountain Water System, soon to be the City of Missoula Water System, needs nearly $100 million in investment to bring it to an industry standard. That investment, under the private model, would never be made. Because of public ownership, though, and the commitment to raise rates only when necessary to operate and improve the system in the public interest, those investments will be made over time. The system will operate to the appropriate standards, and the public will be served for generations to come under local, accountable, elected governance. I sometimes hear folks say, so what does this matter to me? I pay my bill, I turn on the faucet, there's water, end of story. Unfortunately, that's not where the story ends. Imagine paying your mortgage month after month, but never investing in repairs or improvements. Eventually, your home becomes unlivable, or at least miserable to live in. It loses value and function. And it costs much more to take care of all of that deferred maintenance when it's time to move and sell. It's just not the right way to do business. At the risk of being blunt, paying your water bill to a corporate owner of an essential utility is the equivalent of writing a rent check each month to an unscrupulous absentee landlord. In the end, you're likely to pay more for less and have nothing to show for it at the end of the day. Today, we enter an agreement that ends most of the litigation over the acquisition of Mountain Water Company by the City of Missoula. Our negotiations with Liberty Utilities to reach this agreement have been challenging on both sides, but honest and fair. We enter this agreement despite our confidence that continued litigation favors the city, as it has to date, for a couple of reasons. First, both parties are eager to move on. Liberty accepts where it stands, as does the city, and continued litigation will cost time and money and most likely yield similar results, with a couple of exceptions. Chief among them is a clean, orderly, efficient, cooperative transition that serves customers, city, citizens, and employees. Our service agreement, part and parcel of this settlement, allows for us to work quickly and cooperatively to transfer the operations and assets to the city without pain to customers. It's a big deal, and it doesn't come easily with continued litigation. Second, we enter this agreement with the belief that the settlement saves the city and Liberty money. We've always held to the notion that as long as we'll do better in the courts, we'll continue litigating. Liberty's interest in cooperating and settling is a better deal for the community. It ends key litigation, it provides for a smooth transition, and allows for the transfer of funds so that Liberty is paid and the city can get the keys and begin operations. And while we're confident that continued litigation would get us to a similar place, it would take more time, more money, and come with an unnecessarily bumpy transition. Upon approval of this settlement, the transition services agreement and the bond resolution that accompanies them, the city will continue transition work that has already begun with Mountain Water employees and Liberty, and will file the appropriate motions in district court to finalize the condemnation action and take possession. This agreement does not preclude Carlisle from appealing interest and attorney fee rulings, nor does it preclude Liberty from appealing a Montana Supreme Court ruling on property taxes. But Liberty and the city will no longer litigate against one another. The city is reserving its right under this agreement to pursue appropriate claims against Carlisle. Our timeline, which remains necessarily tentative, allows for closing on our transaction this month and taking possession. In the end, the city of Missoula will join all of the other incorporated cities and towns in Montana in owning and operating its water system for the benefit of the public. Thanks to a visionary, resilient city council majority, a dedicated staff who are incredibly committed to public service, a team of passionate, brilliant lawyers wearing white hats, and a community that has been supportive of a long, expensive haul for a community good that will stand long after the participants are reduced to ash and our names are just ink on paper in musty vaults. Those tough votes, those complicated discussions, those calculated risks, that hard work won't long be the stuff of legend, but will certainly be the stuff of life, and I hope you'll approve these documents for the future of Missoula. With that, I'll introduce Tasha Jones, our counsel, who will discuss the general terms of the agreement.
Thank you. Good afternoon. We've presented to you two primary documents for your review, in addition to some ancillary documents that are attachments to the two primary agreements. The first one is the settlement agreement and release of certain claims, and the second is the services agreement. So I'll start by discussing briefly the settlement agreement. If you recall, a couple weeks ago we presented to you the executed term sheet, and we talked about the basic format of our agreement. And the documents that you have before you today really are no different than the terms that we discussed previously that were found in the term sheet. The overall, what these documents do are it ends everything that is pending in district court right now. And that applies to both Judge Townsend's court and what is happening in Judge Halligan's court. These documents end that analysis. What is left are reserved claims by the Carlisle Group. And those will proceed to the Montana Supreme Court for eventual resolution on interest, attorney's fees, and taxes, and we are highly confident in the outcome at the Montana Supreme Court. We believe that the result will be similar, and that will be every time this case has been presented to the Montana Supreme Court, and as you know, that has happened many, many times, the result has been favorable to the city. So we feel great about the reserved claims as well. But let's talk about the settlement agreement. So first off, the settlement agreement in dollars and cents is $93.2 million. And that is, can be broken down in a manner that really you can think about it in two ways. We have the condemnation proceeds, and then we have resolution of the developer's claims in Judge Halligan's court. That's what makes up the $93.2 million. Out of that payment, what happens is there are certain payments and there are certain credits to the city. So first there'll be a payment to Mountain Water Company in the amount of $83.8 million. And what that payment represents is the fair market value of all assets of the system, the attorney's fees and litigation expenses that were awarded to Mountain Water Company, and the post-hearing improvements. So those items of capital improvements that Mountain Water alleged to have made after the hearing where the commissioners set the price of 88.6. So why is that less than 88.6? That's because of Judge Halligan. So in Judge Halligan's court, there were certain items that needed to be paid out of the condemnation proceeds. And so when we look at the other payments, there'll be a payment to the petitioner developers. This is the main group of developers that were represented by Rob Bell and his law firm in Judge Halligan's court. And they'll receive a payment of roughly $6.8 million. After that, there'll be credits. The city will receive credits against the 93.2 for assuming FBO contracts funded by other contracts to the other parties in Judge Halligan's court, and then those group of unnamed funders, that large group of little guys as I've described them in the past, okay? So there'll be a credit for about $1 million to the city for its FBO contracts. There'll be a credit to the county for its FBO contracts. There'll be a credit to the intervener developers. So there was a group other than Rob Bell. They were represented by Kirby Christian and his law firm, and there's a credit for that. And lastly, there's an item for Carlisle's attorney's fees. So $1.1 million roughly will be placed in escrow. That will remain in escrow because Carlisle has appealed both its attorney's fees and Mountain Water's fees. So that is the framework of the settlement agreement. And that completely resolves everything that is pending in Judge Townsend's court, and then it also resolves everything that is pending in Judge Halligan's court. And then there'll be certain claims that will proceed to the Montana Supreme Court following that. So the second part is the services agreement. So if you recall, we moved to compel certain customer data from Mountain Water Company, and as a resolution to that issue and to assist in the overall transition of ownership here, the access and services agreement takes care of transition matters. So this is a complicated process, and what Liberty has agreed to do, and when I say Liberty, I mean Liberty Utilities that owns Liberty Park Water. And so Park Water, the folks in California that currently assist Mountain Water will assist the city as we transition ownership. That's everything from the telephone services that are currently in place to billing, and then to setting up the city's own independent customer service and billing software system. So that's the second agreement. That agreement will last for a period of 60 days following possession. Both agreements have a critical date in them, and that is June 22nd, 2017 is when all of this needs to happen by. And so following the execution of these documents, if you approve them, we will be filing tomorrow, or as soon thereafter as we can, but tomorrow is the plan, motions in Judge Townsend's court to bring these agreements to the court and completely resolve the condemnation case so that we can proceed to closing on the agreements. So unless there's any questions about them, I know you have them and you've looked at them. I'm happy to take any questions, but that's really the overall gist of those two agreements.
Pardon me, and what we'll do is we'll take questions after a motion is on the floor. And why don't we take that first motion, Ms. Marlowe?
Mayor Engen, I move that that the City Council approves the settlement agreement and access and services agreement with Liberty Utilities and Mountain Water for the acquisition of the water system, including conforming changes to the FBO that's financed by other contract amounts as determined by the final reconciliation.
Thank you. That motion is in order, and we'll take discussion and questions. Ms. West?
I just wanted to confirm that I understood the different cases coming out of Judge Halligan's court correctly. So the petition developers are going to be getting a settlement payment, and then all the other developers, including the interveners and the unnamed developers, the city receives a credit, and then the city continues paying the same amount that Mountain Water has until
those contracts are fully paid. Yes.
Thank you.
And I should mention that the reason the motion includes the ability to make some changes for reconciliation. Right now, we're in the process of putting together the exhibits that list every contract and their current balances. So if you look in the settlement agreement, it lists literally to the dollar what is currently owed under categories of contracts. Those numbers are subject to some change based on our final reconciliation because they change over time. As tap fees are paid, then the amounts lessen, and so we are in the process of doing our final reconciliation on the amounts of the FBO contracts, and there'll be some de minimis changes to those numbers, and that's why the motion includes authorization to reconcile those numbers and make those small changes.
Further discussion, questions? Mr. Von Lossberg.
Only questions or discussion as well?
Sure.
I just wanted to say thanks to the team for bringing this to us. I know it's been a difficult, challenging process, but it's very gratifying to see it. And I just wanted, again, say thank you to everybody involved in bringing it to us. Thrilled to see many things, particularly that as we had said all along, that the local developers would be taken care of, whether they were named in the suit or the unnamed ones. And I'm just happy to be moving forward and getting this settled.
Further discussion? Ms. Jones?
Yeah, I just wanted to add to that, that thanks again for all of the work that everybody's done on this. And I hear sometimes from people around town that this just seems to be taking such a long time. Why isn't it done yet? Didn't it go to trial over a year ago? And I just wanted to emphasize that acquiring a utility is an extremely complicated process, and there are numerous parties. It's not just a plaintiff and defendant. There are numerous defendants who, amongst them, they don't necessarily always agree on things, so the City of Missoula is working with numerous different entities. And as the mayor said, the primary goal here is acquiring it, but also doing it in such a way that this crucial service is provided without any issues, that everybody gets water the next day and there aren't any crises. So because of that, it's a very complicated settlement document, and I hope people understand the level of work that has to go into this. This is not typical city government where we can just have all of these open meetings and everybody comments. This is in a completely different arena where there are many different rules applying. So thanks for all of the work that you've done, and I feel like we're 95% of the way there at this point. The 5% that's left is certainly manageable. It's much smaller stakes, and we're where we want to be at this point. So thank you.
Further discussion? Mr. Dubarry?
So I look forward to supporting this motion, and thanks to everyone for your diligent and hard work on this. As the mayor mentioned, I think it's important to move forward at this point. It brings to a close all of the pending court cases associated with Liberty Water Company. It presents the prospect of a smooth transition of ownership and operation, and it provides the opportunity for the city to get on with operations and making the investments that we need to for the water company to continue to provide services to the city of Missoula. And I also would like to welcome the new city employees from what will be the former Mountain Water Company, and I really appreciate their interest in continuing to serve and provide the service that they've done for a long time with great effect. So I look forward to supporting this motion.
Ms. Bentley?
I wanted to welcome the new city employees, soon to be former Mountain Water employees, and thank them for their cooperation in the process and in the transition. And thanks Steve Johnson for pushing that forward and making that happen. I've said lots of thanks in previous meetings, so I know that we got every single employee is coming to work for the city, right? Well, that's great, and I'm glad that that was a cooperative process.
Further discussion? Seeing none, anyone in the audience care to comment on the motion? Seeing none, we'll have a roll call vote.
On the motion to approve the settlement agreement and access services agreement, Bentley votes yes. Cares votes yes. DeBari votes yes. Hedall votes yes. Jones votes yes. Marler votes yes. Swaney votes yes. Van Lossberg votes yes. West votes yes. Would any of you like to change your vote? 9 ayes and 3 absent.
Thank you. The motion is approved unanimously. Our second motion this evening is on a resolution of the City Council amending and supplementing our financing resolution. Ms. Jones, would you like to speak to the nature of this resolution?
There was another litigation between the Department of Revenue and Mountain Water Company, and as a part of that, the Montana Supreme Court ruled that Mountain Water Company owes all their taxes through the date of condemnation. So this was a very favorable ruling for the city of Missoula from the Montana Supreme Court. However, the Montana Supreme Court also left open the possibility that there would be additional claims made after the payment of those taxes. And as a part of the settlement agreement, if you look to the part about property taxes, you'll see from the settlement agreement that we've resolved our claims between one another, between ourselves and Mountain Water regarding property taxes. But Mountain Water they plan to pay all of their taxes under protest and then seek further relief through the Department of Revenue. So in the event something happens in the future that would change the current landscape regarding property taxes, there has been some planning, some what-if planning, and that required a slight modification to the resolution.
Thank you, Ms. Jones. With that, Ms. Marler?
I move that we adopt a resolution of the City Council of the City of Missoula, Montana, amending and supplementing Resolution Number 8144 relating to the city's water system revenue bond anticipation notes, Series 2017A, and water system revenue bond anticipation notes, Series 2017B, to provide for the city's pledge of a general fund obligation bond for the payment of additional litigation liability if necessary, and to provide for other matters properly relating thereto.
That motion is in order. Is there discussion on the motion? Seeing none, anyone in the audience care to comment on the motion? Seeing none, we'll have a roll call vote.
On the resolution, Cares votes yes. DeBari votes yes. Hedall votes yes. Jones votes yes. Marler votes yes. Swaney votes yes. Van Lossberg votes yes. West votes yes. And Bentley votes yes. Would any of you like to change your vote? That's 9 ayes and 3 absent.
And that motion passes unanimously as well. Ladies and gentlemen, we have an agreement. As always, I thank you for your service. We will be adjourned.